See, if a personal guarantor is paying some amount on behalf of the corporate debtor, now normally we see that there is a subrogation, right of subrogation, where he or she can claim it from the corporate debtor. So I just like to understand what whether the surety has the right of subrogation or not, in particular in case of CRP as well as in case of the personal insolvency.
Sir, right of subrogation is a right to the surety, which says that the payment which is defaulted by the corporate debtor, he can recover it from being in the shoes of a creditor. He can recover it from the reimbursements to either to from the promoter or the corporate debtor itself. But however, this is a right, but this has been denied in IBC. And this is what is shocking for the corporate guarantors, that right of subrogation was a right, but it's not something which IBC has recognized it. The rationale is that in case they grant the right of subrogation, then they will be stepping into the shoes of again the creditor and asking the resolution applicant the money. So that will be difficult for the revival of the company, as the resolution applicant or the new buyer will have to pay the same amount of debt to the particular guarantor. So the NCLT in this case has observed that providing the right of subrogation would give the powers to the promoters who contributed to the insolvency of the entire process. So in it was for these situations, the opinion of the court was that the the specific and pertaining to particular cases, that this should not be given to the guarantors. The law of subrogation should not be there for the guarantors in such a case, because it will put them into in an advantageous position. This was clearly established in a case which is COC of SR Steel versus Satish Gupta. The judgment, among many issues, they dealt with this issue of right of subrogation of guarantors. They said that the guarantors filed the claim of reimbursement from a resolution applicant in order to exercise the right of subrogation after creditors invoked their guarantee. Supreme Court denied clearly that the right and held the guarantors does not get discharge of his liability even after approval of the plan. The creditor can still pursue the remedies to recover the contract amount from the guarantor. So that right of subrogation is not granted. And the guarantors definitely will have suffer the setback, as a major principle of law of guarantee was denied to them. And definitely they cannot put into the reimbursement in this case. So in the event of a repayment on behalf of borrower. So this right was clearly denied.